It appears that the extraordinary powers used by the Executive Government under the Emergency Management Act and Public Health Act to close borders, lock down the state, impose social distancing restrictions, mandate vaccines, mask wearing and arrest non-compliant citizens are not enough for the current Labor government, Mr President. The Malinauskas Labor government needs more power and they need it now. But according to the Minister for Emergency Services, the people of South Australia should not be alarmed. These amendments to the Act will only be used to empower the government to meet the unique challenges of cyber terrorism, climate change and natural disasters. Once again, we have the nothing to see here approach from this government, Mr President, the all too familiar spin and stonewalling, while in the meantime this extraordinary bill is catapulted through the House of Assembly without opposition and arrives in this place to be rubber-stamped. And it is an extraordinary bill, Mr President, a bill which further entrenches and broadens the excessive powers obtained under the South Australian Public Health Act in 2022 during the COVID-19 pandemic with limited parliamentary oversight or safeguards and a complete disregard for the individual right or freedom. This is a dangerous piece of legislation, Mr President, one that should be ardently opposed by all members of this parliament, given that we are here to represent the will of the people and to provide some check on executive power, especially in the face of such an extraordinary proposal, which can only be described as a brazen assault on the rights of the South Australian people under the guise of emergency protection. Students of history will be aware of how this strategy has been employed by various totalitarian regimes in the past to exert control over individual citizens and political opponents. In short, never let a good crisis go to waste, Mr President. However, under this proposal before us, the government has introduced a new mechanism that will trigger its emergency powers before the emergency has even occurred. By inserting Clause 21A, it is now possible for the State Coordinator to declare a state of alert if it appears that an emergency is likely to occur or is likely to occur if steps are not taken to prevent it, and it is necessary or desirable to exercise powers. The extension of emergency powers to encompass what the State Coordinator considers a potential emergency is deeply concerning, given that there is no requirement to provide the evidentiary basis for such a declaration. During the COVID-19 pandemic, the government issued an emergency declaration which lasted 793 days without providing any evidentiary justification to the Parliament. If this power is extended to likely emergencies, it must come with appropriate parliamentary oversight, including not only the tabling of evidence to justify the declaration, but also a limit on how many times this declaration can be extended. Under my proposed Amendment 21AA, if a declaration is made or extended, the Minister must provide a report to both Houses of Parliament summarising the advice that was relied on in making or extending the declaration. This is a reasonable measure that will provide an appropriate level of parliamentary oversight and disclosure without obstructing the need for government efficiency in a time of legitimate crisis. Under the government's proposal, the new state alert mechanism will also be applied to emergency declarations made under Section 24A of the Act for any public health incident or emergency. Given the concerns regarding government overreach during the COVID-19 pandemic and the disputed science over social distancing, mask wearing, mandated vaccines and extended lockdowns, any future public health emergency or state of alert should immediately require the establishment of an independent advisory council consisting of members from a wide range of experts, leaders and professionals who can objectively advise the government of the day on any incident or emergency related to the health and safety of the community. In this way, the people of South Australia can have some confidence that the science surrounding any declaration of a public health emergency or alert will extend beyond the bureaucratic corridors of the government. With my proposed amendment to Section 88 of the South Australian Public Health Act 2011, I will be seeking to suspend orders to compel the Minister to establish an advisory committee to provide independent advice to the Chief Public Health Officer and the State Coordinator. This committee will consist of persons with expertise and relevant experience and must include persons who are not state public servants. Above all, Mr President, my greatest concern, shared with the Law Society and many in the legal profession, is the extraordinary powers given to the State Coordinator and authorised officers under Section 25 of the Act and further consolidated by the government's proposed amendments It was back in 2022 when I opposed the retention of emergency powers under Section 25 while removing any safeguarding legislation. Well, here we are again, Mr President, and for the avoidance of doubt, these extraordinary powers currently allow for the State Coordinator or authorised officer to enter, break into land, building structure or vehicle, remove or destroy any building, structure, vehicle, animal or thing, submit any person to decontamination procedures, isolate and segregate people, direct people to undergo medical observation, diagnostic procedures or treatment, amongst other powers. The most concerning clause included in this extensive list of powers under Section 25 is Part 2, which provides for the exercise of any prescribed power. The Law Society and many in the legal profession have called for the removal of this clause or the inclusion of a proportionality clause to counter the clear excess of such a broad provision. To address the issue of proportionality, I've included an amendment to Section 24B1 to ensure that powers exercised under this section must be reasonable in the circumstances. Nevertheless, as stated previously, Mr President, such unaccountable powers are clearly not enough for the current government, as it seeks to reaffirm the excess already evident in the Act, as well as remove any smidgen of possible restraint, as can be seen by the government's proposed removal of the simple phrase, using such force as is necessary. Such an intentional removal of a clause that requires authorised officers to apply force only to an extent that is necessary should concern all South Australians, as it highlights an intention to use force indiscriminately and without restraint. In further extension of Section 25 powers, the proposed clause, Part 5, allows for authorised officers to discharge power even if to do so would contravene another law of the state. In addition to this, Clause 5C states that directions or requirements given by authorised officers, which may be issued orally by SMS or email, may apply to a person or class of persons in any place during any period and may require or allow a person or class of persons to act in contravention of another law of the state and may affect the lawful rights or obligations of any person or class of persons. Mr President, this is nothing short of chilling, especially when you consider the absence of any safeguards or any reference to proportionality or oversight, and certainly no mention of individual rights, other than to state how such rights may be violated. If this was not enough, the proposed insertion of Section 26AB outlines how regulations may modify or dispense with procedural requirements law, procedural fairness. While the dispensing of procedural fairness will only occur on the request of the Chief Justice of the Supreme Court, we must nevertheless ask ourselves, in what sort of system does an independent judicial officer become complicit in the removal of a citizen's fundamental rights? What sort of dystopian nightmare does the government envisage for the future of South Australia? Whatever the future may hold for South Australians, our experience with the COVID-19 pandemic has taught us that it is not so much the virus itself, but the response will ultimately cause the greatest harm to ourselves and the community. The people of South Australia do not have the benefit of legislation which protects their human rights, Mr President, and in the absence of appropriate parliamentary oversight, it is a great concern that this proposal puts the rights and freedoms of all current and future South Australians at risk. This is why I will be seeking suspending orders for the establishment of an Emergency Direction Accountability and Oversight Committee that will require the Minister to report on the reasons for issuing a direction, as well as providing either House of Parliament with the power to disallow a direction. It is my sincere hope that the government and members of this place will consider the importance of parliamentary oversight and proportionality when voting on this proposal, because the people of South Australia deserve a government and parliament that will protect them not only from potential disasters or public health emergencies, but also from the excess of any current or future authoritarian bureaucrat who might abuse these emergency powers to persecute and oppress their political opponents.